Good afternoon and welcome to our Deason discussion series this month. I'm so excited to have you all join us, and I'm really excited for today's presentation, The Appearance of Unfairness, Litigating Race and Criminal Trials with Executive Director and founder of the Decarceration Project, Johanna Jennings. I'm going to tell you a little bit about our program for those of you who are joining us who aren't very familiar with how we work, and then introduce our guest, and should be a really great talk today. I am Kenitra Brown, the Director of Engagement for the Deason Criminal Justice Reform Center, housed at the SMU Dedman School of Law. The Deason Center is 3 years old, and it runs under the direction of our Executive Director, Professor Pamela Mixer. We have a few areas of expertise and research. We look at prosecutorial discretion, Sixth Amendment rights, most specifically, the right to counsel and access to counsel systems, and we look at small, tribal, and rural criminal legal systems. Our engagement programming seeks to make our work and research more visible and accessible. And we also seek to provide platforms contextualizing our work within broader criminal justice, legal, social, and racial justice reform work. Our wide-ranging engagement content and programming is tailored to reach and educate all types of audiences: students, lawyers, practitioners, lay people, lawmakers, court personnel, and all other stakeholders in the system. On that topic, our Deason Discussions series is a topical programming crafted for law students, but open to the entire legal community. These discussions are usually informal and quite interactive and focus on presenting a salient legal issue in criminal law and criminal justice reform. Speakers usually provide a primer or a background for discussion so that the audience can learn about and engage with the topics, especially if they're interested in practicing or improving their practice in criminal law. So general housekeeping, before I introduce our speaker, is that our chat generally stays open in these discussions. So if you want to ask a question, if you want to introduce yourself, please use our chat function to do so. It's generally a really lively and respectful place in our discussions, so we encourage that. And oftentimes I'll drop resources, or our speaker may drop resources into the chat as the presentation goes forward. If you have any questions and you don't want to appear on camera, or you don't want to speak out loud, you can feel free to drop it in the chat and I will ask it out loud when we get to a question and answer portion of the presentation. Now, Johanna Jennings is the founder and executive director of the Decarceration Project, a nonprofit dedicated to mitigating the decades-long trend of inequitable and inhumane mass incarceration. In that role, she engages in projects to alleviate systemic racial inequity, represents individuals directly in strategic litigation, and advocates for policies to reduce mass incarceration. Prior to starting the Decarceration Project, Johanna was a staff attorney at the Center for Death Penalty Litigation, an assistant public defender in Guilford County, I'm going to guess that's North Carolina, and a J. Kirk Osborne Fellow at the Fair Trial Initiative. She began pursuing her passion for indigent defense as an undergraduate at Rice University in Houston. After graduating from Rice with high honors, she returned to her hometown of Durham and graduated from Duke University School of Law. Johanna has represented clients at every stage of the criminal legal process, including the trial level, on direct appeal, state post-conviction, and in federal habeas cases. In addition, she serves on the Forensic Resource Council Advisory Board, is a member of the North Carolina Public Defender Committee on Racial Equity, and is a member of the statewide Racial Equity Network. She's developed expertise in issues related to race, jury selection, and forensic science defense. She's presented at various trainings on topics including litigating Batson v. Kentucky, raising race and jury selection, and challenging forensic evidence. Please welcome our guest, Johanna Jennings.
Thank you so much, Kenitra. It is such a pleasure, and I'm so grateful that you asked me to join today. Preparing this presentation, just doing this kind of thing just renews my passion and excitement and makes me realize how much I still feel so engaged with this work, which is really fun to realize. So I'm going to share my screen here and get started. One thing I wanted to say at the outset is that a lot of what I'm going to be talking about today are things that other people have created or come up with or collaborated on. And so I want to give a special shout out to Emily Coward, who is our policy director at the Decarceration Project. She was the creator of the North Carolina Racial Equity Network, which I'll talk a little bit more about later, which is a training program in North Carolina that I participated in. And also my colleagues and former colleagues at the Center for Death Penalty Litigation, who helped create and co-create many of the resources that I'll reference today. And then just, of course, that those of us in this work are led and inspired by people who have tackled race-based unfairness for many decades, often out of necessity because they themselves were the first Black litigators in these spaces. And so just to recognize those who come before us, those whose shoulders we stand on. I want to tell you a little bit more about the Decarceration Project. I really appreciated Kenitra's introduction there. A lot of what she said is on the screen, so I won't just go over and repeat it, but I'll just give you a little bit of a sense of what projects that we're working on. So we're doing a lot of projects around jury inclusivity, which includes kind of fair cross-section issues, a ton of work around Batson and cause and peremptory challenges, so creating inclusive juries, and a struck jurors project where we go interview jurors who were struck peremptorily by the state or for cause, jurors of color primarily, and talk to them about their experience, because often a lot of the case law is centered on like kind of dry legal principles, and we're not actually getting the stories of the people who go through the process. And so that's something that we feel very committed to. Let's see. So I see that there's a really, the group of attendees is fairly diverse. So there's training directors and students and public defenders and maybe others. And I want this to be helpful for you all. And so I don't want to just kind of talk about something that might not be relevant for you. So the way that I've kind of broken this down is that I'm going to talk a little bit about the global view, and then we can dive in the discussion into things that you all find most interesting or have most passion to talk about. So the other thing is I've only ever done indigent defense, as you can tell from my background. And so that's the world in which I think. So I think when it comes to issues of racial fairness, there's a massive amount of common ground amongst all of the actors in the system. And so I hope that this is something everyone finds the discussion useful and interesting. But if I do just start talking about things from a defense perspective, forgive me, it's truly the world I live in. So first I'll talk a little bit about the training and the areas that race can come into place, and the areas where race comes into play in these trials. And then I'll provide you with some resources that you can adapt and use in your practice or your future practice as we navigate this process of explicitly talking about and litigating issues of race in the courtroom. And then I'll do a slightly deeper dive into jury selection and talk about a couple of cases, specific cases like the Arbery case. And then I will open it up to discussion. And again, I hope you'll just choose the areas that you'd like to talk more about. We can do a deeper dive. So I'll start with training that I've had. This is kind of a compilation, and it kind of goes through the process from, from investigation into the trial and even into the post-conviction process. These are trainings that either I've had or I've trained on as a speaker, or I've been in as a participant, or sometimes just issues that I've had to learn in kind of trial by fire in the midst of trial itself. And my goal in covering this is threefold. I want to provide resources and ideas for where you and your colleagues or your fellow students might encounter these issues of race and trial litigation in the field. I want to give you a sense of areas that I might be able to provide further resources around if you have need for that. And most importantly, I think to truly understand the scope of the way that race impacts trials, this non-exhaustive list that I'm about to give you just shows how deep these issues go, because the reality is, this system, criminal legal system, was utilized as a system of racial control, and we're starting to see some awareness sparking around that, but we haven't actually reckoned with the foundation or done anything to substantially address the fact that this system is a method of racial control, and it doesn't just go away on its own. It's like very much baked into all of the pieces of the system. So while the high profile cases lately are explicitly centered around issues of race, unless you have a trial where literally every person in the courtroom, including every prospective juror, is white, race is going to be an issue in your case and something that you need to be thinking about and addressing. But also by way of kind of background on this training, in 2015, I applied for and was accepted into the first cohort of a grant-funded program in North Carolina called the Racial Equity Network. It was funded by Z. Smith Reynolds, and they had 2 different cohorts, and each cohort went through 2 years of, I believe it was 6 full-day trainings on different topics where race impacts people in the criminal legal system. And I was with about 40 colleagues from around the state, and so we developed kind of a bond or a unity, and I had some other attorneys to turn to on these issues and to be inspired by. So I'll go through some of these issues. So some of the things that we're trained around and that I'll provide some resources on are racial disparities in stop, searches, and arrests. This would include things like driving while Black or brown, the relevance of race to quote unquote consensual encounters, equal protection claims, and then things like challenging proxies for race that are used to support reasonable suspicion. So like if an officer says there was a reasonable suspicion because of X, Y, and Z, but X, Y, and Z was really just a proxy for race in their case, challenging that type of thing. Cross-racial identification, that was a day-long training about challenging issues around people's inability to identify characteristics and faces across different races. Racial disparities in pretrial release, I feel like that one is really well covered and talked about, and so I won't go too deep into that at this moment. Investigating racial history. This is something that I've done a lot more of in the last 4 or 5 years in my practice, and it's been really impactful. This can include things, it basically is, investigating racial history involves looking at all of the structural racist systems that are at play in your client's life and how they have affected your client specifically. So it can be things like looking at health outcomes, and historical practices like redlining to show how it impacted your client. So it could be things like food deserts or air pollution for, educational disparities, school to prison pipeline information. So for example, I had a client who had diabetes and really high blood pressure, and all of his family members had died really young. And he was in his 30s, and they were asking him to take a 20-year plea offer. And I used health disparity data and birth rate, or I guess life expectancy rates by zip code, to show the prosecutors that a 20-year outcome in his case was actually a death sentence versus what it might be in someone a similar age, a white person who grew up in an affluent community. So that type of thing. Plea negotiations and selective prosecutions, that one I think is pretty self-explanatory, but looking at disparities there. Fair cross-section challenges. This is about getting the people in the door into the jury pool who actually look like the people in your community. Cause challenges, this would include things like questions that people will ask in order to intentionally strike BIPOC or Black, Indigenous, and people of color jurors, and things like asking about law enforcement or feelings of the system. So these are things that I'll talk actually more in depth about this later in the slides, but it can also include things like death qualification. So in death penalty cases, you can only sit on a death penalty jury if you believe in the death penalty, and Black communities are less likely to believe in the death penalty because of the history of lynching in our country. And I'll talk more about that as well. We also were trained, and I've done a ton of training around Batson objections, and really the cause challenges, Batson objections, and talking to jurors about race are the kind of bread and butter of what I am most passionate about and talk about most of the time. So you should always reach out and be happy to chat with anyone about those 3 topics. It's my favorite thing about what I've done in my career, I would say. One of the things that we've been working a lot on developing training around is courtroom dynamics. This is an area that's really ripe for more consideration, and I think is something that's really interesting in these national cases that are getting national attention, because it's so important what the dynamics are in the courtroom. So some of the things that we've been thinking about are courtroom security, which is things like shackling, but not just shackling, like anything that communicates to jurors or the judge that your client is a scary person, which is especially problematic if you're like me, a white woman with a Black or brown client. Anything like where the bailiffs sit or where the courtroom security sits and whether they look like they're about to jump in at any moment to protect you. Things like that are implicitly communicated to jurors and create really unfair courtroom dynamics. Things like cultural competency issues, so like court reporters not understanding African-American vernacular English. I think I said that right. I always abbreviate it. And so they mistype what is actually happening in the courtroom. So things like getting actual recordings of the courtroom so that you can correct those mistakes, which sometimes end up being really significant. And the best example of this is there's a case where the court said that the person did not invoke their right to counsel because it was a Black defendant and he said, I want a lawyer dog. And they said, well, he said he wanted a lawyer dog, not a lawyer dog. And so they found that he did not in fact invoke his right to counsel. So those kind of cultural competency issues really play a very unfair role in our system. Use of stereotypes. I have a case right now where the prosecutor in closing argument, I have the case in post-conviction, the prosecutor said he chose to run with the pack. And this was right after the Central Park 5 case up in New York, where they used that exact language very explicitly in media, like in big, huge headlines, or cases where a prosecutor is referred to a client as a big Black bull. These types of things are really obvious, but you also find a lot more subtle kind of microaggressions in these courtroom dynamics. And then also Confederate monuments outside the courthouse, inside the courtroom. Who are the pictures on the wall? What are the statues? And with this, I would say also paying attention to other microaggressions that Black and brown people experience when they come to the courthouse. So that could be like, I know when I worked in Guilford County in Greensboro, North Carolina, you had to put your hands on a table and bend over to even enter the courthouse and be patted down. So that kind of humiliation and degradation, which hits harder for a Black person because of our histories, our country's history of slavery and racial control. And then also racial disparities in sentencing, and then finally disparate treatment in prison. So among the other issues in prison, they have their own kind of internal punishment system, and it has these same issues of everything that I've just talked about. So people are more likely to, Black and brown prisoners are more likely to receive infractions, more likely to receive solitary confinement, all of these other things that create collateral consequences and residual trauma that is lasting. So that's a lot, but I wanted to give you a global picture of what are some of the things that we can talk about today, what are some of the things that I talk a lot about and think a lot about in my work, and what are some of the things that are just truly influencing all of these various trials that you hear about, as well as the many, many hundreds and thousands of trials that happen that you don't hear about in the media.
Johanna?
Yes.
I'm so sorry to interrupt. 1 second. You mind switching to your earphones?
Sure,
we can hear you, but your audio is fluctuating a little bit.
Yeah, absolutely. Hold on 1 sec. Let me get it situated here. Okay, is that better? Okay,
Yes,
great. Good. So I'm going to give you a whole host of resources. You don't have to kind of internalize this in this moment, but these are just things that I think might be helpful for you if you are doing this work, if you're training on this work in particular. So I put, and I will go, I'll just show you, I've created a shared Dropbox that I'll leave open for at least a couple of weeks so you can download what you want to, a shared folder. And I put a bunch of resources in here. One of them is the slides from today. And so anything that has a link to it, you can go through and pull. So for example, this website, which I'm about to show you, this online available manual for free, which I'm about to show you. But I've also put in here a lot of things that I have created along with colleagues, and none of them are perfect. Like, I'm a trial lawyer, so I very much am like, I'm a satisficer, like just get it down, get it done, have something in front of you. So all of these are things that could be improved, edited, and you could create and modify for your own state and practice. But here's a variety of bias checks. So a bias check for defenders. I think one of the things that happens, and what we know from the research, is that just knowing about implicit bias is not enough to stop implicit bias. You have to actually take action in order to check it. And so I use this as much as I can when I'm dealing with my case, and it just goes over some of the risk factors for when bias is going to creep into my decisions, how to kind of mitigate it, how to check it, and some of the processes for reducing it. And so I think that's one thing that we haven't talked nearly enough about, is that the actors in the system are our own biases. You know, we talk about jurors with biases, we talk about witnesses with biases, but it's our own biases are at play as well. There's also some prosecutor and a decision maker's bias check in here, so you could use that for judges. One of the prosecutor ones is specific to California because they have a special process for, as well as Washington State, they have a special process as well for peremptory strikes and jury selection. That's a little bit of a deep dive at this moment, but I can explain that later if you'd like. And then the other resources, there's some template motions for fair cross-section issues, jury selection resources. There's some discussion here about your legal rights to ask jurors about Black Lives Matter and their feeling on the Black Lives Matter movement. And then this is, I think, one of the most helpful things that I've used, which is it's a quick guide to Batson objections, and it goes through how I literally keep this in front of me in court, and you use it to make your Batson objection. It's a two-pager, or one-pager front and back, and is super, super helpful. So these are just all things that you can explore, on your own as you. There's some sources for primary sources for bias. So this talks about, like, what are the articles that talk about implicit bias? What are the articles that talk about, the presumption that we impute to particularly Black men of dangerousness and guilt? These are all things that I'm hoping you'll be able to use in your practice. I also just wanted to share with you, this is a link that is in the PowerPoint slides for this manual that Emily Coward, our policy director, and Allison Grind, who's now a Superior Court judge, created, called Raising Issues of Race in North Carolina Criminal Cases. The thing is that so many of these issues are constitutional ones, and so a lot of this is going to apply other places. So I'd encourage you to check this out. You can see there's 10 chapters going through each step of the process. So for example, eyewitness identification, and it talks about, what are the basis of how do we know that there's cross-racial impairment? What are the risks of misidentification? How can you raise this? How can you, voir dire on it or cross-examine on it? So some really great tools there. And then I've also included a link to the North Carolina Racial Equity Network, which has program materials. So for example, there's the last training that we did was in storytelling and the ethics of interracial and intraracial representation. And so you can find links about how to tell your client's story and how you can kind of ethically engage with this work. So I just wanted to direct you all there. And that's kind of and then a couple other things I'll point to quickly. So I've included the template motions, the quick guides. I've included a link to a website that has by city the maps of redlining. And this one, you know, for example, you can look at Dallas and see this is a map from 1937 of Dallas. And I don't really know that much about Dallas, but I'm willing to bet that this is still the richest part of the city. And you can do that for most cities. And this is the actual map of the areas that were redlined. And so, you know, it's literally, you know, I think probably a lot of you are familiar with Isabel Wilkerson's book, Caste. This is literally like the caste system, like, okay, this is an undesirable place to be. So if you're an undesirable, you can live here, but nobody who lives there gets a loan. And this is from, you know, 80, 90 years ago now. And it's just pretty darn incredible to look at the ways that if you look at maps of air pollution, maps of poverty, maps of racial segregation, how incredibly closely these maps continue to track. So I would encourage you in your case to at least just look at what does the redlining map look like in your client or in your case's location, because it's pretty shocking. And then this is a website for anybody who does death penalty work or is interested in death penalty work called Racist Roots. And it's about how the death penalty is just another Confederate monument that we need to knock down, how there's a very direct line from lynching and racial terror to the death penalty as we know it today. So I would encourage anybody in doing death penalty work to definitely check that out. There's tons of just incredibly helpful pieces there. So that's that. I want to do I want to pick one area to do a slightly deeper dive, because I do think the kind of storytelling piece of this is so crucial to really bringing to light how problematic these trials are in terms of fairness. I'm including a quote here from Justice Liu in dissent from I believe it's the California Supreme Court. And I know that it's a case out of California. And if you click on this, you'll in the PowerPoint PDF, you'll go to the case. It's triplet. So I'll just read this. To many people, excluding qualified Black jurors based on their negative experiences with law enforcement or the justice system must seem like adding insult to injury. It is time we reassess whether the law should permit the real life experiences of our Black citizens to be devalued in this way. At stake is nothing less than public confidence in the fairness of our system of justice. So I think what speaks to me about this quote is that, and the reason why I feel so passionately about jury selection, which is the area that I kind of want to take a deeper dive on, is that, you know, I kind of, rightly or wrongly, I almost expect my clients to be treated unfairly. Like most of my clients have been charged with something horrific. There's often pretty strong evidence in the case, and they are just part of like a really traumatic and, you know, unconscionable system. But what shocks me literally every time I do it is how poorly prospective jurors of color are treated in the system, because my client, you know, should be treated the same way, should have the right of innocent until proven guilty, you know, should be given that presumption. But as a realist, I know that's just not going to happen in the vast majority of cases. But these jurors who come through have not done anything, and all they've done is report for their civic duty. And they go through some real trauma going through the jury selection process. And, you know, I've had jurors who have told me they can't sit on my case because they've been on a case before. They were the only Black juror on that case, and it was a horrible experience, and they can't go through it again. And I've had jurors who've told me horrific stories of their own injustices that they've faced. And what ends up happening for those jurors is they get struck, often for cause, not even a peremptory strike, but they get the state basically says, this juror can't be fair and impartial. And the judge says, yeah, well, they're not fair and impartial because they don't trust law enforcement, or they have a negative view of the system. But what's just bananas about it is that we all are starting to recognize like the real life experiences of Black citizens are that they have in the vast majority of cases been treated poorly by law enforcement, or they have in the vast majority of cases, had either they themselves or had a significant other who was treated poorly in if not the criminal legal system, some other systemic, system, healthcare system, and so this distrust is like entirely rational. And then we add insult to injury, just as Justice Liu says, by saying, oh yeah, and also because of that, you can't be on a jury. And so it's just super, super problematic. Studies, it's not just the affront to these jurors that is the problem. It's that diverse juries actually do a better job. So studies show that they deliberate longer, they evaluate the evidence more thoroughly, they recall facts more accurately, they're more likely to talk about the way that race impacts the case. So we want both prosecutors who want to do justice and defense attorneys and civil litigators should want diverse juries because they're going to do a better job. That's what the research shows us. And so it's just pretty mind-blowing to me that like this is just part of the ho-hum every day of the system, including in these really high-profile cases, the Rittenhouse cases, the Arbery cases, and we just kind of don't react as best I can tell. And I do want to play a clip so I did this, I had this really cool opportunity to be part of a mini documentary, almost like a mini podcast with two students at the Duke Center for Documentary Studies, Shakira Rahim and Khalid Bashir. And they produced this really cool little, 6-minute clip of talking about jury selection. So I do want to play for you. Kenitra, if you can give me a thumbs up if you hear this when I start playing it, that would be super helpful. I'm just going to play for you about 3 minutes of this audio. And this is about jury selection. It's about this process of jurors coming in and because of their experiences getting kicked off of the jury. 5, I believe it was, prosecutors attended this training called Top Gun. It was at the North Carolina, the Conference of District Attorneys, and they had a sheet in there that said articulating juror negatives for Batson purposes. There's a Supreme Court case, Batson versus Kentucky, that says you can't use race as a factor in determining who to strike from a jury. Well, they had given the prosecutors a sheet that said, here are all the things that if you're kicking off an African-American juror, here are the race-neutral reasons that you can use to give to the court as to why you're kicking off this juror. I'm Johanna Jennings. I'm a staff attorney at the Center for Death Penalty Litigation, which is here in Durham, North Carolina. So basically, here's how you can explain your strike of these Black jurors that you want to kick off. And the Batson justifications are things like defies authority.
Heard that before.
Didn't make good eye contact.
Oh, so now you want me to look you in the eye?
Inappropriate dress.
I heard that shit last week.
Overly aggressive.
Just say I'm too Black.
These are the things that would cause, Black people to be harassed or lynched or jailed for decades and centuries in our society. I was looking at a non-capital trial transcript of a case that I tried here in Durham recently, and what I noticed is that Black man after Black man kept getting struck from the jury, and it was for reasons like they would say things like,
well, my car was broken into and my stereo system was taken. I called the police, and the police arrested me because I had a warrant on a traffic ticket. And so I don't feel great about police because I called for help and they arrested me.
That person's removed from the jury because they can't be fair and impartial under the way that our system functions according to the judge. Progressive prosecutors, right, like people who I think hold values of racial equity, they'll say, well,
if somebody doesn't like the police, then they aren't fair and impartial.
And what we're just kind of not realizing, coming to grips with, is the fact that we can't kind of historically and currently and presently have one set of expectations and have one set of the values in the way that we treat people. And then when we bring people in the courtroom, say,
you don't get to have those experiences. You can't bring that into the courtroom.
The number. So I'll leave that off there, but I just wanted to go through one more little bit about this and the way that these trials affect jurors of color. And this is a picture of Marcus Ransom. He was the only Black male juror in the Ahmaud Arbery federal jury trial that just wrapped up recently. They convicted on a hate crime for, I think McMichaels is his last name. And there were 2 other Black jurors, 2 women Black jurors, and then Marcus Ransom. And this, I put a link here to the New York Times article. I won't go through all of it because I do want to leave sufficient time for questions, but I just found it so incredibly compelling to read his story. And this is kind of what we've been trying to do with the Structures project as well. You know, this was, Mr. Ransom is somebody who has experienced a ton of racism to the point where he said he's almost numb to it. But you know, there were many moments throughout this trial where he was crying, where he was processing this evidence that was just horrific. And so I think about him, I think about the way that this case will stick with him, the way that this trauma was put on his shoulders. So it's just an interesting, there's just so many dynamics that kind of come together here. But, you know, these are, I feel incredibly grateful for him because this is the kind of thing that we know we are losing in so many other instances, that kind of personal connection to the experience of, you know, to diverse experiences. And so I'll leave it at that. I can talk a lot more about jury selection generally and jury selection in that particular trial and in that state trial if you all would like, but I don't want to cut off any of our time for questions. Let me just glance at my notes to make sure there's nothing else that, I'll just note that in the state trial for the Arbery case, the defense struck 11 of 12 Black potential jurors, but Black people made up a quarter of that county or 27% of that county, but only 1 Black juror was seated. And the judge actually found that there appeared to be intentional discrimination of the panel, but he said he couldn't change the racial makeup because the defense attorneys were able to give these non-racial reasons, like I referenced in that sound clip. They were able to give these non-racial reasons for their decisions, often which are just kind of thinly veiled racial reasons. And so because they'd been able to explain to the court why besides race those individuals were struck, the jury was allowed to stand. Now that is not actually the law. That's like a massive misinterpretation of the law that judge had, but it's a really common one. And so that trial, they also came back guilty in that trial, I think just because of the extreme heinousness of the case. But, you know, even even where there was a conviction, there was just this massive amount of unfairness in jury selection. So I'll end here. I'll turn off the screen share so we have time to discuss. My contact information is on that slide, and you should feel free to reach out anytime. And again, you can find the PDF and the Dropbox link that also has my contact information on that last slide. Okay, I think I have stopped my share and I'll turn it back over to Kenitra to lead us in the discussion.
Okay, so I'm going to take moderator's privilege and I'm going to start first where you just stopped. You said that in the Ahmaud Arbery trial, a judge massively misinterpreted Batson. Let's start there. What is the law? What's the rebuttal? What would have been the proper rebuttal? And I think that's a good place to do kind of a run through of Batson challenges, what the proper response would have been, and what your training or what type of training you would give defenders.
Absolutely.
In this situation.
Yeah, absolutely. So that cheat sheet that I shouldn't call it a cheat sheet, but that quick guide that I gave earlier is a really good run through of what the law is. But essentially what the law says at the US Supreme Court level is that if race is a significant factor in the decision, then the strike must not stand. So judges are under this misunderstanding that if race is a factor, but not the only factor, as long as there's a legitimate, so basically what happens is there's a strike, one of the parties says the strike I object, the strike was based on race or gender. And then the burden shifts to the other party to provide a race neutral reason. And then the burden shifts back to the objecting party to prove what's called purposeful discrimination. That's a really problematic standard because purposeful discrimination is explicit discrimination, but we know that people implicitly discriminate all the time. And so the standard itself is already just incredibly unhelpful. But the judges make it worse by basically saying, well, if you can provide me a race neutral reason, then I won't grant the Batson objection. I'll deny it. And so like in this case, the judge said, I do think race is a reason. And the reality is if race was a significant factor, that Batson objection should have been granted. But he's like, but you provided these other reasons, which are race neutral. And like literally a 4-year-old could come up with a race neutral reason for striking a juror. You can literally say anything. Just don't say it's because of their race or gender and you're okay, you know? And so sometimes they even provide like reasons that like some of the ones we've seen in North Carolina are like membership in the NAACP or that the person attended an HBCU. I mean, those have been found to be race neutral by our appellate courts, which is like laughable. So it just proves how prosecutors can literally say anything. And so that was a real misapplication. And had that gone up on appeal, I feel confident that at some point that would have been overturned, but because it was the defense got the jury they wanted, right? So it was the issue becomes moot, but.
I can keep asking questions, but I want to make sure that I'm catching anyone who may have a question before I keep going. So if you want to ask a question, you can either use your raise hands function, or you can just unmute yourself and ask the question before. I have a long list, guys. So.
I wanted to ask, and thank you for talking to us today. I wanted to ask how common that misapplication of the standard is, because I worked on a case 2 winters ago that basically had that exact problem, but it went up to appeal to the Fifth Circuit and they did the exact same misapplication. So is it like that widespread, or is it just certain circuits that are hostile or kind of ignorant to how it actually works?
Yeah, thank you for that question. That's a great question. It's super common. And in fact, in North Carolina, we just 2 weeks ago had our first case where
where an appellate court in North Carolina for the first time found intentional discrimination or a Batson violation for a juror of color. They had found that defense attorneys had discriminated against white jurors, but they had never found the reverse. And the reason for that was because despite there being really good United States Supreme Court case law that is actually pretty clear on this, the individual states' interpretation has always been terrible, and states will always kind of use their own case law first. And so like in North Carolina, we had case law that was just blatantly wrong. And so what we did here, and I think it was incredibly effective, was we just started marshaling the troops, and we had people start writing law review articles calling out the North Carolina and Supreme Court and Court of Appeals, saying you've never reversed on Batson, your law is completely out of whack. And we started that back in 2009. And so it took 13 years, but it does feel like the floodgates have kind of opened. I wish I had the slide up right now. I don't, but they've now sent, over, since 1986, so 30 years plus since Batson, they weren't sending any of these cases. They weren't reversing, and they weren't sending the cases back down to the trial court for further hearing. In the last 2 or 3 years, they've now sent something like 10 cases back down to the trial court for new hearings. One of those was a case that I tried of an 18-year-old kid who was given life without parole. And because they sent the case back down on Batson, we were able to resolve it at 23 years. So he'll get out at 41. And in that case, there was only one black juror struck because the pool was so white, despite Durham being literally half black. I had a pool where 2 of 12 jurors were black, and they were both black women. And so the only strike of a black person was this black man. And I objected under Batson and used that quick guide that I provided to you. And the court eventually did send it back and said that the judge didn't hold the hearing properly. And so we were able to resolve it. So yeah, it's incredibly, all of that to say, like, a hopeful note, right? Like, it's incredibly common, but when we started pointing it out, the court got embarrassed and they realized, like, we really didn't mess this up. And the cases that we've gotten about 4 or 5 Batson decisions in the last few years. The most recent one, which was a reversal, have corrected the bad case law, and it's now been brought into like right into line with the U.S. Supreme Court case law, which is such a it's like both a relief, and it seems like almost infuriating that it would even get to that point. But as you've seen now in your case that you worked on, it does in fact happen. So yeah, I think all of that to say, like, if we just keep pushing, we will eventually prevail and get the law right on these things. Because, and then the other thing to note in this area, in the Batson context, is that we shouldn't be satisfied with Batson, because that burden of having to show purposeful discrimination when we know that implicit bias plays such a large role is too high. And in Washington State and in California, they've now adopted these like objective observer standards, which is basically like, if an objective observer would think that race played a role in the strike, then the strike doesn't stand. And so that's really a much fairer method. And I think it's made a big difference in Washington State. California's is newer. So in places where there is kind of political will, where you do have, I mean, I think in Washington State that happened in large part because of Jeffrey Robinson with the ACLU. But in places where you either have like a really powerful actor like a Jeffrey Robinson, or where there's the political will to make fair, inclusive juries, that's a really good goal to set for people working on policy.
Thank you.
Thank you.
I'm going to guess that no one will step in. So I think one of the hardest things that practitioners have difficulty with is that we know these things are in play, right? Some of it is not new information, but there is a difficulty in thinking about how to bring it up in court, or trying to figure out the best way without any backlash on your client, or any backlash on you as an attorney or an advocate in a courtroom. So are there any particular tips or tricks for actually being so explicit about race in the courtroom, particularly in places where there's oftentimes could be negative consequences for you or your client when that's happening?
I'm so glad that you asked that, because that raises something that I very much meant to say, which is that I think when we think about these national cases, the first thing, besides them just being like horrific and heartbreaking and just, I mean, how are we still here, right? Like, how is this happening? Beyond that, we really can use the fact that there's this constant flow of there's always the next incident, the next untimely death, the next case of abuse or assault. And so what I've found recently is that those cases, like before every jury trial that I've had, there's been some horrific incident. So I remember one where Heather Heyer was killed in the Charlottesville rally. And then literally the next week we were in court doing jury selection. So these cases are on the jurors' minds. And I think it's such a nice way to one, to honor the people who have been the victims in these cases, that just one slight way in which their death doesn't have to be in vain, or their case of assault or extreme aggression, is to start talking to jurors about those cases. And if your judge won't let you bring it up explicitly, I think you can kind of dance into it and be like, has there been anything in the criminal justice realm in the media that you've been paying attention to lately? It doesn't have to be like, how do you feel about the Black Lives Matter movement? How do you feel about the Blue Lives Matter movement? Although I do think those questions are incredibly effective at ferreting out people's views. But it can be a little bit less explicit and let the juror bring it up. And then once the juror brings it up, then you can play it off of other jurors and talk to them. Like, Mr. Smith has been paying attention to the Arbery verdict in the federal Arbery hate crime case. Has anybody else paid attention to that? Has that affected you? So I think that because we have this constant drip, drip, drip of these like horrific cases that you can't help but see even if you're not a really avid media or news intake person. It gives us this really amazing opportunity to talk to jurors without it feeling personal to our client or without it feeling like an attack on them or on the court. And I think it's a little more palatable in that way to judges as well. And I will say that your own racial identity and your client's racial identity are things that you have to think about, and that it's what I've seen in my own personal experience is that the white lawyers who bring up these issues receive a lot less backlash and threat to their livelihood than the Black lawyers. And so I really think that's our duty, and it's really imperative that we are the ones who are kind of leading on that front. So often we put like the harms and the duty to repair our, the kind of the original, all of these consequences of the original sin of our nation of slavery on Black people or on other people of color. And it's like, that is obviously further perpetuating the harm, but also I've seen instances where Black colleagues have really faced real harm and threat from raising these types of issues. And I know that while I might get some blowback, it's not the kind of thing that's going to end my career. And so I can go in there and have that privilege to go in there and say that and talk to those jurors. And once you get the jurors to start thinking about race, they will bring it up. So once one person starts talking about a media case or something. And another way that you can do that and make it an issue is, for example, if you're objecting under fair cross-section, then every time you express satisfaction with the jury, you can say, the defense is satisfied subject to the motion for fair cross-section. Well, then the jurors start understanding like, oh, so there's not a fair cross-section here. So then, I've had trials where I have transcripts where the jurors themselves are telling the judge, when I look at this jury pool, it doesn't look like the community to me. Like this looks like a very white jury pool, and that's concerning to me. And then, they are then having those conversations. So there's ways that I can cue them, even if I feel like I can't be as explicit as I would like to be. And so those are also, opportunities. But I guess I would say particularly, for lawyers who don't feel truly threatened and vulnerable, like even if it is uncomfortable, that's just you reaching your growing edge and like really push it. Because I used to tiptoe around these topics, and it was sometimes effective and sometimes not, but I get so much more valuable information now that I'm willing to dive in. And so just my own anecdotal experience is like the jurors are seeing the stuff, they want to talk about it, and you're going to have so much more information, and you don't have to make decisions based on your stereotypes yourself if you know things about the jurors, so that's the key to not kind of making poor decisions, is to get information. And so it's really key to do that.
Again, I can keep going, but before I ask my next question, anybody have a question they want to ask? Okay, I don't see hands. All right, so we're talking a lot about juries and jury trials, but we know that dockets are backed up over the next few years. We know that sometimes some cases are plead out. 90% federal and state cases are plea negotiations. How do we advocate for clients, especially where race is playing a role? Like you said, unless you're talking about all white actors, generally every case you have in every criminal case you have will deal with race. So how do you start addressing these things, or addressing race, bias, unfairness, and plea negotiations in pretrial release negotiations and all of that? Because I think we're going to see, or at least we already are seeing and will see, with the delay in the docket, longer pretrial detentions, and clients being more willing to negotiate pleas for release rather than wait on trials and things like that, because of this nationwide problem with the size of the dockets.
Yeah, thanks for that. Yeah, I feel like that's so true, that I spend a lot of time thinking about jury trials, but the reality is 98%, 96%, depending on where you are going to be pleas. I think one of the things to do with that is people are really interested in hearing about things it's more interesting to hear something that's like directly related to you. So to the extent that you can get data about your prosecutor's, hometown, like where you are. I think, like, for example, showing that map of Dallas is going to be more interesting than if I had shown you a map of Durham, for example, because it feels more personal and you just know more about it and you're more curious, and it opens up that kind of curiosity muscle that we all have within us. And so I think getting specific stories, racial history stories about where your client is from, and especially if that is also where the prosecutor's from, can be really impactful in explaining their mitigation story. So I do mitigation stories for all my clients, even if it's not a capital case, even though the mitigation isn't technically relevant to like a guilt innocence phase of a trial. If you have a prosecutor who's not mitigation impaired or who's not kind of empathy impaired, you can, which, I like to think is most of them, most prosecutors would be open to stories of mitigation and be willing to tap into that empathy. If you can kind of story tell in a way that brings in that racial narrative, I think that's really impactful. I think some of the ways that our racial history has led to disparities in basic necessities and basic life rights, human rights, is really impactful. So things like stories of food insecurity, or, there's just so many things that even Black prosecutors that I've talked to have never had to experience. And so if you can, through storytelling, make those stories real, whether they're implicitly or explicitly about race, maybe it's more of a poverty story, but I think that's really impactful, and I've had really good success with that. And it is so much more humanizing for your client, and it's so easy, I think, for people just to become like a faceless number on their docket and not a person. So I guess I always feel like going back to storytelling and humanizing is like always the answer to almost any question in life, but especially these cases where you're trying to work something out that's fair. And obviously, if there is any explicit racial component in your case, like I have a client now, the officer was posting on, at the same time that he's pulling my client over while he's driving while Black, he was also posting anti-Black Lives Matter stuff on Facebook and checking into the Capitol on June 6th or January 6th, and all of these things that it's like, okay, this is not a fair person to be deciding whether to pull my client over and what if anything he should be charged with. And so obviously in those cases, being willing to go to the prosecutor and really raise it is going to be key too. But I think even in cases where it's less explicit, there are ways to kind of research and pull in that interesting racial history.
We talked a little bit about backlash on your colleagues of color, your Black colleagues who bring this up. But has there ever been really any resistance to courts or other prosecutors who just, I don't want to hear it? It's very, very, very race neutral. They don't want to hear anything about race, its action, any of that. So when that happens, are there any tips that you have there, or any ways to think about moving forward on those types of cases? Or even, when you're talking to a judge who's just, this evidence can't, or any discussion about race, any of this is not allowed in the courtroom. So, or not allowed in their courtroom. Any other ways that you can think of where, what's another way to advocate for your client?
I think using those guides that I provided, that guide with links to articles and things like that, the more you can kind of pull it into like a social science research realm, the more you can say like, Judge, this is relevant, and here's the research to show you that. And it's not just me saying that because I want to, get a good outcome for my client. I think that's one option for people who will listen. There's definitely this residual adherence to the colorblind philosophy that we all learned in like the 80s and 90s and maybe the O's, where it was better to not talk about race, like I don't see race, that kind of thing. There's that still very much exists. And then the other line that you will get from people, and I've heard this from an elected prosecutor himself, is that well, everybody who comes to me is Black, so there's nothing I can do about it. Like the people committing the crimes that's not my, that's not, I can't do anything about that. And so he told me all my victims are Black, all the defendants are Black. So what am I going to do about it by the time it gets to me? And I think that, you know, in that case, maybe trying to collect and challenge that person's data, because that's not actually true. It just feels that way because it's so overwhelming to walk into a courtroom and see so many Black and brown faces. But also then in that instance, really trying to paint the bigger picture of like structural racism and how we got here, I think can be impactful. There's some people for whom it's just not going to land. But I don't believe that they're not hearing it. So like, even if they kind of push back against you and they like say like, I'm not going to consider this, and you can't unring that bell. Like, it's in their mind. It's in their mind for that case. It's in their mind for the next cases. So I still think just like, even if you don't get anywhere in your case, which I've never found it to be true that I didn't get anywhere by kind of raising it, maybe one time, but there's still just value. There's also just like immense value for your client, like having your client feel seen and heard and having their story told. Like, there's so many ways that there's so many positive ripple effects of your willingness to dive into these issues. You know, education for all of the actors in the courtroom and the way that they carry that with them forward. And, you know, I guess it is really like my clients and them feeling that I'm genuinely trying to overcome those barriers between our identities and connect with them. Like, that's actually been maybe one of the most powerful ramifications of raising this. So yeah, so excellent question. It's, you know, not a one size fits all, but I just think, like, particularly for people on the defense side of this, like, none of us got into this to have it be easy. It's just, you just keep going. So
That actually is a really wonderful way to end. I love that it's bigger than it's basically the residual impact on the rest of the courtroom. Before we're at the hour, so I want to respect everyone's time. I'd like to leave you a chance to have any last thoughts, any last minute questions from anyone or from Johanna. This has been great. I agree with Monica. So any last minute thoughts from anyone, including Johanna?
Oh, go ahead.
Johanna?
Oh, okay. I thought maybe Raquel had unmuted. Yeah, I mean, nothing, you know, everything that I've talked about today is something that I can, you know, talk about for many, many hours on end, as you can probably tell. So always feel free to reach out to me, or if you feel like you heard something that would be helpful for a colleague, feel free to pass that on. This is the reason why I do this work. This is the, I think, most important thing that any of us can do for future generations, those of us involved in this work, is to really try to be part of that racial reckoning and not be deterred by the backlash, by the retrenchment, by the ways in which it's hard. So I just really so much appreciate this opportunity to talk. It's been so fun and rewarding for me to prepare for today and to think about this. And I'm really happy to have an opportunity to connect with a fellow Rice Owl, because I don't get as many of those up here. So you probably see a lot down there, but not as much up here in North Carolina. So thank you so much.
Thank you so much for joining us today. The presentation was wonderful. I'm so thankful that you provided us with resources. Quick reminder for everyone, she's only going to keep it up for a couple of weeks. So download what you can as soon as you can. Everything is so helpful. Thank you for the slides. Thank you for everything else. If anyone has any questions, please feel free to email us at the Deason Center at deasonjusticecenter@smu.edu. If you have any questions, you can also see our upcoming events. We have a few more events this semester, and we're adding more. If you want to see what's on our calendar, just drop on our website and hit our events link. And I think I didn't miss anything, but I'm so grateful for this presentation, Joanna. Thank you so much for joining us. And I actually, we'll plug in your brain. I think I might bring you back for something else, because there's something so wonderful about providing resources. And maybe next time I can actually pull in the CLE credit. So thank you all for attending. Have a great afternoon, and we'll see you soon.
Thanks so much. Take care.